maximum retention period of 3 years from end of permissible fund life. So these are safeguards, but within the safeguards, the real difficulties, operational difficulties have been noted, and therefore a proper mechanism has been proposed. Now, when they are treated as inoperative funds, so then the compliance requirement will be lowered because obviously there will not be any active fund management there. So therefore, discontinuation of periodic filings, PPM updation, and performance benchmarking will take place. So obviously, this will expected to reduce the compliance burden on AIFs with no active fund management activity while retaining necessary regulatory oversight. As you are aware, the process of every decision that there is a committee which goes into this advisory committee. In this case, for example, the APEC, and then public consultation process has taken place, and we have received quite a bit of support from comments which have been received, feedback which has been received. The second proposal is relating to the FPIs to permit net settlement of funds for transactions done by them. It's again an ease of doing measures. This currently FPIs settle their transactions with custodians on a gross basis, which results in additional costs for FPIs, including funding costs and foreign exchange slippages. Recognizing these concerns and with a view to enhancing operational efficiency and reducing cost of funding for FPIs, it has been decided to permit net settlement of funds for outright transactions done by FPIs in cash market. And what are these outright transactions? That is transactions in which there is either purchase or sale transactions, but not both in a particular security in a settlement cycle. Obviously, the request was that we should have a general netting, but then we have a problem where when FPIs are not allowed to do day trading, and therefore if you have this complete, even in the same script, then that risk will arise, and therefore only the outright, which means that either purchase or sale. The rest is to be given on a non-outright basis. Now, the proposal is expected to reduce the cost of funding for FPIs, particularly on index rebalancing days when outright purchases and sales occur in incoming and outgoing index constituents. So the timeline for this is on or before December 31, 2026, because it will require necessary system and process modifications. The third proposal is to review the minimum value of investments by individual investor in social impact fund of AIF under SEBI Alternative Investment Fund Regulations 2012. The individual investors in social impact fund today, they can make, they have a minimum requirements of rupees 2 lakh. But the zero coupon, zero principal instruments, minimum application size is 1,000 rupees under ICTR. So we have brought it in consistence with that, which means that retail can participate in social impact fund, particularly in in issues which are going through the social stock exchange at a value of minimum value of rupees 1,000 instead of rupees 2 lakhs currently. This will promote both the social stock exchange issuances as well as the retail participation in these. The next is the measures to enhance ease of doing business for the activities of InvITs and REITs. This is again relatively an exit issue. Whenever you are reaching at the end of scheme, you have to wind up the scheme. So the present regulations require that a special purpose vehicle under an InvIT is required to invest at least 90% of its assets in infrastructure projects. Upon the conclusion of concession agreement, the infrastructure project in the SPV ceases to exist. However, the InvIT may have to continue to hold investment in such SPV since an immediate sale or winding up may not be practically possible due to pending claims, litigations, tax assessments, defect liability period under the concession agreement, etc. So to address this issue, InvITs will be permitted to continue to hold investment in SPVs post conclusion or termination of concession agreement. InvITs shall be required to either exit investment in such SPV or acquire new infrastructure project in such SPV within 1 year from the later of. So there are three things: either completion of concession agreement, or conclusion of pending claims and litigation, or completion of defect liability period. Whatever is later, within 1 year of that, you have to actually exit investments in such SPV or acquire new infrastructure project in such SPV. So the basic thing is that the InvIT should continue to hold investments in infrastructure, but when you are actually winding down because of the conclusion of concession agreement, you have post-concession formalities and requirements for which you require a certain period for which you have to continue the SPV. Now, obviously, when during the process, there will be some funds which would be available, which means that additional investment options for temporary deployment of funds by InvITs and REITs, and to mitigate concentration risk, InvITs and REITs will be permitted to invest in units of liquid mutual fund schemes where the credit risk value is at least 10 and which falls under class A1 or class B1 in the potential risk class matrix. As you are aware that there is a risk class matrix where we have an interest rate risk and there is also a credit value risk. And then there is, in that matrix, currently what is permitted is only 12 class A1 and credit risk value 12. And this is being permitted now 10 and above and class B1 and above. This will permit better deployment because there is very few debt mutual funds, liquid mutual funds which are available in the category in which presently the conditions hold. And the larger category, which is actually a B1 and 10, is where the maximum possibility is there for investment. Therefore, they would be in a position to invest there as well. Then we have another one is that between public and privately listed InvITs, today there is a difference. While publicly listed InvITs are permitted to invest up to 10% of the value of their assets in greenfield infrastructure projects, which means under construction infrastructure projects. The privately listed InvITs are not allowed, which is actually the private listed InvITs in fact have basically for institutional investors, so there is much risk there, less risk there, as compared to publicly listed projects where retail is also invested. So therefore, obviously, there is we should also make that available. 10% of the value of their assets in greenfield infrastructure projects should also be available to the privately listed projects. Now, fourth point is that we have leverage. InvITs can actually have a leverage up to 49%. There is a set of requirements, and exceeding 49% and up to 70% of their value of their will be allowed. We can be allowed for fresh borrowings for capital expenditure, major maintenance expenses, and refinance of existing debt, which was originally utilized for permitted purposes subject to condition that only the principal portion of debt is financed. So InvITs are being allowed the leverage exceeding 49% up to 70% of their value provided that's used for capital expenditure or major maintenance expense for road project, and then third, refinance of existing debt which was originally utilized for permitted purposes. Now, this will mean that greater flexibility and also the fact that capital expenditure is to be encouraged in bits, and major maintenance expenditure under roads is currently not allowed to be capitalized. So therefore, it is separately being allowed because sometimes the concession agreement itself requires the concessionaire to make such capital expenditure. But since there is no extra, since the assets will be actually reverting back to the main concessioning authority, so therefore it's not permitted to be treated as capital expenditure. So capital expenditure in cases where the owning up is possible, major maintenance in case of roads where owning of the assets is not possible, and therefore the development expenditure would be permissible, and for that you can take the borrowings. The next proposal relates to the amendments to fit and proper person criteria under the SEBI Intermediary Regulations 2008. The regulatory objective of this particular amendment is to balance the principle-based criteria. And what is that principle-based criteria? That only persons with integrity, honesty, ethical behavior, reputation, fairness, and character operate in the securities market. Under schedule, they will come in under 3A. Now, some of the point was some of the automatic disqualifications were inserted under the schedule under 3B, I and 2B2I, where based on FIR or charge sheet, one had to do the automatic disqualification. This particular itself is under legal challenge, and right now there are 16 petitions in Bombay High Court. This has been reviewed, and now what we are saying is that the rule-based criteria of pendency of criminal complaint or FIR file or a charge sheet concerning economic offences shall by itself not be ground for automatic disqualification. However, the extant principle-based criteria shall apply on a case-to-case basis as I have described. The criteria, which is, persons with integrity, honesty, ethical behavior, reputation, fairness, and character. Now, obviously to apply it, we are also saying, now there is a conviction criteria, disqualification. That means disqualification upon conviction for an offense. That is being retained. Earlier it was only involving moral turpitude. Now it's going to be expanded to include conviction for any economic offense or any offense under the securities laws. Under IBC also resolution happens, and the company can come back. Intermediary, which is the company, cannot be allowed to be disqualified when it can be revived. So in that case, only when the winding up order is passed, then only the disqualification should take place. Then applicant intermediary shall be required. Another one, we are making it now clear that applicant or the intermediary shall be required to inform SEBI within 15 working days of the recognized stock exchanges of occurrence of any event envisaged under clause 3B involving itself, its KMPs or persons in control, in case they are violating any of the fit and proper criteria. An express provision for granting a reasonable opportunity of being heard before declaring a person as not fit and proper shall be inserted. Currently, this is not there, so we want to expressly state that before anyone is declared as not fit and proper, before that a reasonable opportunity of being heard should be given, like a natural justice demands. This is being made explicit now. The default prohibition of 5 years from applying for fresh registration in cases where no time period is specified is being omitted, because it's being made very clear that the period of prohibition extend prohibition to apply for registration during the period of prohibition shall continue. So if there is a order which will say that the period of prohibition, it will operate for the duration of that period. The orders can be, in terms of specific time period, like 2 years, 3 years, 5 years, or it could be contingent also. Sometimes order could be till you do such and such thing. Then, it is like a contingent on something. But whatever is the order which is mentioned, the prohibition period will follow that. And we will not presume a prohibition of 5 years. A category of proceeding for incurring disqualification in cases where show cause notice has been issued by the board should be limited to proceedings under section 11B1 and 11(4) of the SEBI Act. Further, the time period of non-consideration of registration upon issuance of show cause notice by SEBI shall be reduced from 1 year to 6 months. So these amendments obviously will come into force on the date of their publication in the official gazette. With respect to pending cases, administrative steps may be taken wherever required to withdraw such show cause notices cases if such matters would not warrant issuance of show cause notices under the amended provisions. The next decision is in respect of the recommendations of the high-level committee and the decisions which the board has taken on those recommendations. So as you are aware, a recommendation HLC was created, was set up, and then with a certain terms of reference, and the committee had submitted the report. It was also put to public, is put in SEBI's website. A lot of comments were received. There were also a lot of media comments. There were also comments internally from employees. So after considering all that, this matter was earlier discussed in the last board. In that board, it was decided that since there are a number of issues in that, it will require further deliberations. So in today's board, this matter was discussed, and so these decisions have been taken. Now, the following key recommendations of the high-level committee have been approved by the board without modification. The first, uniform application of restrictions on investments and trading in equity and equity-related instruments other than permitted investments in mutual funds, etc., to chairmen and whole-time members as currently applicable to employees. There is a bit of a difference today between the employees and the chairman and WTMs. This will be same going forward. Further, the HLC has recommended that new investments in any pooled vehicle may be permitted, provided the scheme is professionally managed by a regulated market intermediary. This has also been approved by the board. Chairman and WTMs may be required to choose one of the following 4 options for investments held by them at the time of joining. Either liquidate the investments, or freeze the investments, or sell the investments according to a trading plan, or sell the investments without a trading plan with prior approval. Investments in equity and equity-related instruments in commercial ventures, including unlisted companies, must be fully liquidated or kept frozen during the tenure of the chairman or the WTMs. Vested options, if any, must be exercised before joining SEBI. 4. Chairman and WTMs to be brought within the definition of insider. 5th, the definition of family for members and employees to be aligned. The aligned definition of family would be spouse, dependent children, including adopted children and stepchildren, any person for whom the member employee serves as a legal guardian, and any other person related to by blood or marriage to the employee or to his spouse and substantially dependent on such employee. A member or an employee must disclose any negotiation agreement for any future employment. Establishment of a digital system for management of conflict of interest, whistleblower system for reporting actual, potential or perceived conflicts of interest, and training and development programs to foster a culture of ethical conduct. Then the next category is the board took note of the public and media comments, privacy and other concerns expressed by employees with respect to other recommendations of HLC. After consideration, the board approved the following key recommendations with appropriate modifications. On public disclosure of assets and liabilities, it's been decided that the immovable property details of chairman, WTMs, executive directors and chief general managers, in fact this was what was also recommended by HLC, CGMs and above, may be publicly disclosed in line with the requirements already applicable to Government of India, All India Service and Central Services officers. However, details of assets and liabilities other than this in the format to be prescribed would have to be internally disclosed to SEBI. Ethics infrastructure. The new Office of Ethics and Compliance for Management of Conflict of Interest framework for employees will be established. For the present, it will be supervised by Chief Vigilance Officer, SEBI. Third, investment restriction on spouse and dependent family members. So investment restrictions, that is direct investment in shares, applicable to chairman, WTMs, employees, may also be applicable to their spouse and dependent family members, except investments in unlisted securities, ESOPs acquired as a part of pay package, and use of discretionary portfolio management services to manage their investments. Discretionary portfolio management services are the one where the fund manager acts independently. That means it is the discretion of the fund manager and not the person who is holding the securities. That means it is akin to a concept of a pooled vehicle fund manager. These restrictions would apply prospectively and existing investments shall be grandfathered. As you are aware that even for employees, presently the employees are not permitted to invest in stocks, but they can only invest in mutual funds. But there are no such restrictions on their spouses currently. Now these restrictions are being brought in. Limit of 25% on investments with a single intermediary. New investments by employees, WTMs, chairmen in products managed by a single SEBI registered intermediary may not exceed 25% of their financial portfolio. Further, if the limit is breached, the concerned official will have to recuse from all matters involving that particular intermediary. So this is again in line with HLC recommendations. However, this is something which has been put in this clarifying that this will be, of course, I think in the HLC also they recommended only new investments. But then we are also making it clear if the limit is breached, the concerned official will have to recuse. On disclosure, employees, WTMs and chairmen to make initial annual event-based disclosure of assets, liabilities, trading activities and relationships to SEBI. Part-time members from the ministry, RBI, may be guided by the conduct rules of their parent organization. Other part-time members may continue to make disclosures to the board about holding of shares and past professional assignments, for which the look-back period is being harmonized to 3 years as applicable to WTMs and employees at the time of assumption of office. They shall also disclose holding of shares on an annual basis as per the current practice. No public disclosure is required for part-time members of the board. Recusals. The board also accepted general recommendations in case of recusals relating to material, financial interest and other circumstances that may require recusal as given in the HLC report. The board also approved that a digital system and recusal framework may be put in place to record disclosure of conflicted relationships as well as to the process recusals, including grant of approvals. Recusal proposals may be dealt as per delegation of powers in SEBI. The board decided that the decision of the board on the recommendations of HLC may be suitably incorporated in 2008 Code on Conflict of Interest for members of the board, which is called 2008 Code, for voluntary adoption as per the current practice. The board, after deliberations, decided that the following recommendations of HLC be referred to the central government for consideration. A. Notifying a separate set of regulations for board members. As the central government is the appointing authority and prescribes the terms and conditions of service of board members, the central government will be the appropriate authority to take a decision in this matter. The recommendations of HLC and the revised code may be referred to the central government. B. Oversight of conflict of interest of board members. As regards oversight of conflict of interest of board members, including creation of an oversight committee on ethics and compliance, the recommendation may be referred to the central government, which is the appointing authority. Thank you very much.
Thank you, sir. Thank you, sir. So we shall start with, please, one question at a time.
Of the events that took place at HDFC Bank last week. If you are examining comments made by the board, comments made by the departing chairperson in further detail than what is available in the public domain, if you are contemplating any action in any kind in terms of investigative action or a line of inquiry or certain prompts to the board of that bank, sort of to shore up governance, and if you are in conversation with the departing chairperson to verify the comments he made in his resignation letter, barring which, will there be any action on the resignation letter that spooked the markets?
I think first of all, I would say that immediately after the board, the primary regulator, RBI, has taken it on board and also issued a press release and also took due decisions in respect of appointment of someone, one of the members of the board as the chair for a certain period. And I believe there will be many other occasions on this because the primary regulator also closely supervises the banks. So the other part I would like to say is independent directors. For independent directors also there is a code for independent directors which is encompassed in regulation 25 of LODR, also as schedule 5. Under schedule 4, schedule Roman 4 of the Companies Act 2013, it refers to the code for IDs under schedule I4, where IDs are required to adhere a certain code of conduct. And IDs have, where they have, in this code, it's written that where the IDs have any concerns about the running of the company or a proposed action, ensure that they are addressed by the board, and to that extent that they are not resolved, insist that their concerns are recorded in the minutes of the board meeting. Also, there is in 11, at point 11, a report concerns about unethical behavior, actual or suspected fraud, or violation of the company's code of conduct or ethics policy. So there is a process which is there, and obviously, if there is any concern, then it has to be there in the board meetings and board governance framework, and it can't be just general thing. I think it's very independent directors hold very important position, while they may have also, explicit powers, etc., to question the companies and so on so many fronts, including also in the audit committee, including in the NRC. They are also required to, be also protector of the interest of the minority shareholders and act responsibly.
Sir, if I can follow that up, there is still some confusion among stakeholders on what the chairman's resignation letter said and whether there is significant truth in it when he pointed out to ethical differences. Those words led to a significant share price impact. Is SEBI going to look into discerning whether those words accurately represent events in the board meeting?
Well, I would not like to publicly state anything, but I have really quoted to you the obligations. And obviously, nobody is expected to make any insinuations without actually proper evidence and recording, unless, because this has an impact. If you say that any such comments, given that those comments do have an impact on the minority shareholders' interest, so the independent directors have to be actually also be responsive in terms of whatever they say and record. And we have to see what is there in the governance, in their board meetings, etc.
Will you be asking for board meeting
Menika, we can
minutes?
move on actually. So
Just one quick question. Will you be asking for board minutes? No?
We started with one question and there's a
I
whole
think specific detail of investigation cannot be discussed in press conference. So it will be good if we can move on, yeah.
Sir,
Sir, two very quick questions. First one, as far as the board meeting, the minutes are concerned, you've of course mentioned that the high-level committee has reached a conclusion on wherein the details of assets, liabilities, investments, everything will be disclosed to the internal committee, and this is aligned with a lot of the bureaucratic way of working things. I just want to understand, do you think there could be a problem which could also come because of this thing later on, where certain disclosures could fall under ambiguity, whether how explicitly they were disclosed if they're not out in the public domain? Did the board also discuss that certain members can be kept where these disclosures can be made public, and for certain, the rest of the employees, it can be done to the SEBI board? Second question is with respect...
I'm not clear about your question, if you can state clearly.
I just wanted to understand, do you think the board also discussed the fact that there could be problems with respect to ambiguity if these disclosures are only made to SEBI and not out in the public explicitly? Or could there be a more bifurcated way of doing it, wherein certain core members, the disclosures could be made public and for all the employees only to SEBI as you've prescribed? That is the first question.
I'm still not clear, but I'll answer anyway. The issue is that I stated very clearly, the board decided that the disclosures will be on immovable property, details of the family in case it's earned from your resources, right? So your property details. Rest of the assets and liabilities will be, given it to the SEBI internally to the office of OEC, which is being established, and that will be there in the board. So for the internally, even still there. So it's not something new. Even now also, SEBI employees are giving, even now also WTM members, etc., are giving these details to them. Except that now there is no public disclosure yet on anything. So public disclosure to the extent of immovable property will come for offices, CGMs and above.
So second question is
In respect of property which is from their resources.
correct. So second question is on buybacks. I mean, we've seen a lot of companies having cash with them and wanting to do buybacks, especially in the current market situation, but not being allowed to do open market buybacks. And this has been one of the demands from a lot of these companies. Is SEBI looking at considering open market buybacks for companies wanting to do so, especially after the change in the taxation rules?
So I think this was because in relation to certain income tax rules amendments, it was not practical, although system was provided, but that was not picked up. Now if we have certain other proposals under the finance bill, which will make it feasible, then we will also suitably adjust that systems. Because of the buyback taxation, now that there is a certain proposals in this present finance bill, but that will, when enacted, we can follow it up with that.
Sir, hi, Sajid here. This is with respect to HLC on conflict of interest. You briefly touched about the fact that immovable property would be made public, but others will not be made public. We have cases where judges' assets and liabilities are made public, people going to public offices or contesting a public office are made public. Why have you left that part of it? At least when the WTM is from outside and joining for the first time, why can't that be made public at that point in time?
No, it has been made consistent with AIS and CCS rules, which is for all India service officers as well as the central civil service officers, as well as the officers of all the state governments. The rule is only immovable property. And what you said about Supreme Court judges, I don't know whether what you're stating is a really correct thing, whether it is all assets and liabilities, or I'm not too sure. I have to check.
Sir, my second question is on AIF. Private credit markets are under stress globally, and in India also there are some signs which is coming in, especially private credit, which is in structured form in through the AIF vehicle in real estate and other sectors. Have you looked at the AIF vehicles and how they are performing, especially with respect to the investment going on real estate or mid-cap companies where there's a balance sheet stress which is there?
No, it's okay. I mean, AIFs are supposed to be in, that is one relatively riskier area, and which cases to more illiquid kind of assets. And therefore also when while we are really developing the AIF framework, we are also cognizant of the fact that we cannot allow too much of a retail exposure to AIFs. And this should be, so therefore our intent has been in the last few months to promote the accredited investor concept to really be going in investing in the AIFs as much as rather than exposing them to retail. But this is one essential area in the capital market. There are different segments, and everyone caters to different segments, and there are different kind of risk-taking groups. And opportunities should be available for all kinds of people, all kinds of risks groups, as well as all kinds of different opportunities.
Is there a risk which is coming in this segment, especially for a much more educated investor who's participating in the AIF or structured products?
No, we don't see any risk because we always keep, monitoring any risk which is coming to.
Mr. Pandey, hi. Good evening. I'm sorry, just one quick question. So in the HLC recommendations, we are seeing that investments in equity and equity-related instruments in commercial vehicles for the chairman and WTMs have to be liquidated or frozen. This includes unlisted companies. But then when we talk about investment restrictions on spouse or dependent family members, it explicitly, circumnavigates the unlisted securities space. So if the chairperson and WTMs can't invest or hold their unlisted securities, why is this provision there that their spouses or dependent family members can? Because we know that the unlisted market is something that there have been conversations of trying to, regulate that market, and one of the biggest companies with a liquid unlisted market, NSE, is out there for an IPO. So does this not raise a few questions on why the unlisted securities for spouses and dependent family members has not been included in the ambit?
See, the point is that, the spouses are, when we say the spouses are acting independently on their own resources, right? So it's not that. If you can't circumvent it by putting your money through your spouse, that's not permitted. It's only when the spouses are also independently doing and someone is running a company, having a business, that is where the thing is. So where you are taking away the rights? The question is that when it comes to be listed category, then obviously there will be an issue where who will be the existing shareholders and what lock-in periods and requirements will be applicable for them. And specific recusals might come also. So it is not that the recusals will not come. There are two different things. One is investment restrictions, another is recusals. Recusals may come in on various grounds. Recusal may come, for example, that if one of your relative in the expanded definition, as per the Companies Act, which we are going to adopt, right? Suppose he is going to be a KMP somewhere and you are handling the case, in which case you must recuse.
So the system of recusals that digital system...
seriously restrict to one question.
Good evening, sir. Khushbu Tiwari here, sir, from Business Standard. So you are saying that in the 6.5 para, the recommendations of the high-level committee and the revised code may be referred to the central government. So the points that we have discussed today, these will also be referred to the central government along with the request for a separate set of regulations for board members. So is there any possibility of any changes being recommended from the central government to these recommendations that have been approved today by the board? And sir, one more question. You have said that the investments will be permitted provided that the scheme is professionally managed by a regulated market intermediary. Regulated only in India or overseas also? Or including FPIs and everything?
I think when we say regulated, wherever it is permitted.
Overseas regulators or something?
Overseas regulator, there the risk is much less actually, because the risk is more here because you don't decide about any of the people.
Because investments in FPIs through certain other, for example, any family house or family office or any other such fund stationed in some other jurisdiction, and investments from there, does this include those investments? And the first question also on the central government.
The point is it has to be pooled vehicles. So the second one, I'm coming to your first question. That is on recommendations. So the basic thing is that we cannot actually regulate ourselves in that sense. I'm talking of chairman and WTO members, because the law says something which is that central government will do. So therefore necessarily, if suppose some recommendations of HLC is there, obviously we have to refer it to the appropriate quarters for decision. Notwithstanding that, the board took a decision that we will voluntarily do that. See, even if it is not a part of a regulation, we have been following a voluntary code of conduct, which when HLC went into that, they actually found it inadequate. They said that you should be doing all this, so that we are trying to do whatever something as it is, whatever they said, something with some modifications, and adopting it. And then we'll start complying it, even if it is not as a part of any regulation.
And sir, because you said it is
Khushbu,
pooled-
I think we'll
Just ma'am, follow
move
up
on.
the
Good
pooled
evening,
investment
sir.
part. Just a follow up on the pooled investment part.
Let
sir.
us give everyone a chance.
Yeah, Kanchan, we can start.
Good evening, sir. My name is Kanchan and I am from CNBC Awaaz. And my first question is, several of today's decisions, be it on fit and proper FPI netting and AI flexibility, appear to ease regulation rather than tightening them. Is SEBI shifting its philosophy from investor protection to market facilitation?
I think we are actually following a system of optimum regulation and a balance. We have been discussing about HLC, which is actually self-tightening. So not only on ourselves, that those people who are sitting on the dais here, also on the employees who are here, there and all that, and SEBI employees, certain additional responsibilities being taken, certain new restrictions being taken, certain things being more streamlined and there. So these are all in the nature of, I would say, you could say, ease of doing business for media or ease of doing business for others and tightening for us. So we have to take everything on that merit where if your regulation is serving a purpose, that purpose must be served. Suppose that regulation is creating a problem, and those problems are actually well articulated and discussed and in the committees and then brought out in the public consultation where we give a wider opportunity to people, including media, to comment on the pros and cons of that. And thereafter we take a view. So therefore it is, I would say, a very progressive approach to legislating something where we are able to, create problems, sort the problems, and wherever the regulation, of course, will be there, that will also be there. But regulation for regulation's sake, that is not the intent.
Sir, Jayashree from Reuters, sir. With the netting proposal, you have taken over like 5 to 6 big structural changes for foreign investors since you took over. FPI outflows are still continuing. We are at a peak of 2 decades. Having said that, have we seen any uptick in the FPI registrations as such from SEBI side? Because most of these measures are to get them more onboarded in India. Of course, we understand portfolio flows continue, but mostly from the onboarding process. Have we seen any uptick?
Yes, I think flow of registration, FPI registrations continue.
But do we have any data, sir, just to substantiate if there has been any uptick in the data of FPI?
We'll give you what are the new registrations. We'll make you available.
Hi, sir.
सर एकता फ्रॉम जी बिजनेस सर आज मिनिस्ट्री ऑफ फाइनेंस ने कहा सर मेरे 2 सवाल होंगे थोड़े मैक्रो इश्यूज पे मिनिस्ट्री ऑफ फाइनेंस ने आज कहा कि सेबी ने कुछ 1,30,000 से ज्यादा फिन इन्फ्लुएंसर्स जो कि नकली एडवाइस दे रहे थे गुमराह कर रहे थे उनको फ्लैग ऑफ किया है अगर आप लोगों को आसान भाषा में समझा सकें क्योंकि बहुत से ऐसे इन्फ्लुएंसर्स भी होते हैं जिनको आप एट वैलिड से चेक नहीं कर पाएंगे या सेबी टूल से चेक नहीं कर पाएंगे क्योंकि वो पैसा नहीं मांग रहे हैं कोई ग्रुप ज्वाइन करने को नहीं कह रहे लेकिन हाँ उन्होंने शायद किसी कंपनी से पैसे जरूर लिए हो लोगों को एडवाइस करने के लिए और फिर लोग उनसे इन्फ्लुएंस हो जाते हैं तो आसान भाषा में अगर एक फेक फिन इन्फ्लुएंसर को पहचानना और रियल इन्वेस्टमेंट एडवाइजर को पहचानना
रियल इन्वेस्टमेंट एडवाइजर को तो हम तभी पहचानेंगे जब वो रजिस्टर्ड लेगा हमसे रजिस्ट्रेशन and we are encouraging people to really register them. We have eased their onboarding. We have taken several measures to see that, and we'll continuously see that more and more such people are there, and we are seeing more interest also coming on board.
लेकिन कंटेंट से नहीं पहचान पाएंगे कोई ऐसा टूल नहीं आया क्या सेबी में
नहीं कंटेंट में हम लोग जब वो वायलेट करते हैं लाइन क्रॉस करते हैं तभी हम एक्ट करते हैं
और सर अभी आप
यदि कोई अच्छी बात कह रहा है तो वो कभी हम उसको निकालते नहीं है
नहीं आई वाज सेइंग फ्रॉम अ इन्वेस्टर पॉइंट ऑफ व्यू फ्रॉम अ व्यूअर पॉइंट ऑफ व्यू हु इज ऑन सोशल मीडिया वो अगर कंटेंट देख रहा है हाउ कैन ही आइडेंटिफाई दैट दिस इज नॉट अ रियल इन्वेस्टमेंट एडवाइजर
ये हमें समझाना होगा, मे बी इन्वेस्टर अवेयरनेस करना होगा कि देखिए आपको जो दे रहे हैं, जैसे ही आप उसको बहुत स्पेसिफिक एडवाइस देने की कोशिश करते हैं, तो आपको जब आप उसको प्रिंसिपल समझा रहे हैं तो डिफरेंट है। जब आप उसको ये कह रहे हैं कि आप एक्स और वाई में करिए, और जब आप उसको भ्रमित कर रहे हैं, गलत एग्जाम्पल देके कह रहे हैं कि देखिए हमने तो इतना कर दिया।
हमने अभी रिसेंटली सर्कुलर भी इशू किया है कि रजिस्टर्ड इन्वेस्टर एडवाइजर जो है वो जब भी कोई एडवाइस करेंगे तो उनका रजिस्ट्रेशन नंबर सोशल मीडिया पे डिस्प्ले करेंगे। उसका इफेक्टिव डेट अभी कुछ महीनों के बाद में है, लेकिन वी हैव इशूड द सर्कुलर।
और सर अभी आपने एक LODR की चीज को एक्सप्लेन किया, मैक्रो लेवल पे समझना चाहेंगे सर, अगर रेजिग्नेशन लेटर को क्या एक एविडेंस के तौर पे नहीं लिया जाता? दूसरा, अगर किसी ने बोर्ड में जाके, क्योंकि यही बैंक कह रहा है कि बोर्ड में जब हमने पूछा आपको कोई इशू था तो उन्होंने बोला कोई इशू नहीं है, अगर बोर्ड की मिनट्स में वो नहीं आ रहा लेकिन रेजिग्नेशन में आ रहा है, तो ये कॉन्फ्लिक्ट को सेबी किस तरह से लेता है?
मैं इसमें अभी आपको कोई क्लियर कहना नहीं चाहूंगा जब तक हम लोग इसमें पूरी अच्छी तरह से अनुध्यान नहीं कर पाए। लेकिन मैंने आपको इसलिए कोट किया है कि ये कहने के लिए कि कोई भी इंडिपेंडेंट डायरेक्टर या कोई भी जब ये कहते हैं तो रीजंस देना जरूरी है। यदि आप रैली जाना चाहते हैं तो आप जा सकते हैं, यदि आप कुछ किसी कारणवश जा रहे हैं और वो कारण आप बता रहे हैं तो उसको आपको कन्फ्रंट भी करना पड़ेगा, उसके पीछे भाग नहीं सकते आप। आपको कहना पड़ेगा क्या ग्राउंड पे वो हुआ है, क्योंकि वो तो चीजें आपके बोर्ड के मिनट्स में आनी चाहिए, आपके कम्युनिकेशन में भी आनी चाहिए। चीजें हम वेग नहीं रख सकते हैं इसमें।
So just because it's vague, I
will give a chance.
Hello, sir. Nimit Dikshit from NDTV Profit. I wanted to ask, sir, is SEBI concerned about the US private assets, private credit stress right now that it's facing with the redemption requests? And is SEBI concerned about if that will track into India? And is there a conversation around that? What is your thinking?
At the time, we don't have any such thing.
Hi sir, Kabir here from Infomist. So a couple of clarifications from the circular. Firstly, in the recusals part, there was a recommendation on making the recusals public. What would be the thought behind dropping that recommendation, sir? And secondly, there's a word which has interested me, that is voluntary adoption, sir, in point 6.4. Sir, just would want to understand what would that mean, sir?
So the HLC did not recommend that all the recusals will be made public. They haven't recommended it.
It was a
they have said a summary of such recusals will be given in the annual report. Right?
Yes, sir.
So suitably, I think that will be incorporated. The question is that there will be several recusals. You can't give, each person-wise recusals on everything. And in how the summary would be given, that will be taken care.
Okay, sir.
But there was, every recusal to be given on board, public recusals, that was not recommended by HLC.
Okay, sir. And sir, voluntary adoption?
Voluntary adoption means, basically, I think the issue was whether there will be a specific rules or a regulation which will have the legal sanctity to follow, right? That rules which is under the statute or the regulations which are then made under the regulatory powers given in the law. Now, for that to happen, we have to say, whose power is that? Now, there are certain things which we cannot administer ourselves in the way we want to regulate. But certainly we can always say that this will be my code of conduct and I'll follow it. Of course, the government can ask us, actually notify also. In that case, it becomes a rule, right? Rule or regulation where we must follow that. Notwithstanding that, what we are saying is that this voluntary, which is 2008 also, has not been notified by the government, but still is subsisting, right? So that is being updated. for the present. Yeah, till the time, I mean, yeah. So that means we don't want to postpone its application.
Yeah, so
Exactly.
Yeah, so it is binding for us since we've already decided.
Hi.
Ma'am.
Please continue.
No, I just wanted to get clarity. So that means that effective the board approval, whatever changes the board has approved, those will be modified in the code of conduct. But sir, another thing that I wanted to bring up was that, as you mentioned earlier, the committee had found that the current code of conduct is inadequate. But then some of the major issues and concerns that were brought up earlier, the currently approved framework is not really answering all of those recusals, more transparency, the whole idea or why this committee was formed initially, because there were questions raised about we don't understand what is happening within SEBI. We understand there's a set code of conduct being followed, but now that only the, like you said, immovable property is being made public, no other, there are modifications and many changes, and we can understand privacy issues. But you see, the core questions that were raised a year ago are not really being answered. So do we think we'd be still looking at more to do that, more changes that can be made within while addressing the issues, or this would be it?
See, you have to really balance this. Like, if your investigation is going on, how much of that you will continue to day-to-day report? From the point of media, your interest would be different. You would like, as the things go, you should get that information. But there are many stakeholders involved there. In many investigations, they end up in, there is nothing is found. Now, the disadvantage of always on the report is the damage gets done immediately. Because as we say, someone says something in a listed company, it is an impact. And subsequently, when something is there, you can't say it is the impact has been fully recovered. That particular day, someone has been impacted. He will not gain it back. So therefore, I think we have to be very clear is that, we have to release information in a manner where it has reached a certain stage. And that is the reason why on specific cases, we also do not react. Because of this very reason, because we also have a certain responsibility as a regulator, because what happens if this is not found to be true? And secondly, we also want everybody to know at the same time. Not that someone knows it earlier, someone knows it later, that creates a lot of arbitrage. So there is a lot of nuances to exactly telling you at what stage and others. But I can only say that here we believe in a lot in transparency, and we are as much trying to be transparent as much as possible, subject to our own responsibility as a regulator to keep mum when we are required to keep mum.
That corner. Sir, you typically keep mum only. No, Menka, seriously, no. There are a lot of people waiting here. Sir, you were saying something?
No, I was just saying that the TOR of the committee reflected the concerns which were expressed in media earlier. So perhaps it may not be correct to conclude that the concerns have not been addressed. The committee has given the report as per the TOR, and many key recommendations have been accepted without any modification. So I think we need to be a little careful when we say that the concerns have not been addressed.
Saurabh Mukherjee from
Some
ENI,
major
sir.
ones.
Ma'am.
Can we have some other?
Ma'am. Saurabh Mukherjee from ENI, sir. My first question to you, sir, is will the new Office of Ethics ensure transparency for SEBI's new leadership while keeping their specific asset details private? And the second question is on the West Asia conflict. Today, Prime Minister Narendra Modi has expressed concern and hinted for lasting effects for a long time. Given the fact that there will be an impact on Indian economy, WPI, CPI inflation, FDI, FI inflows, I would like to know your remarks on PM remarks and how is SEBI planning to boost and protect investors' money in these tough times?
And that's a very general question. And as a regulator, we are trying to do our best to see that our capital markets, they continue to remain at the full market integrity level.
Hello.
Anurag?
Hello. Sir, the first question. Sir, the first one, will the Office of Ethics ensure transparency for SEBI? SEBI's own leadership while keeping their specific asset details private?
So we are having a press conference and quite an open press conference, and we are asking questions. This is a sign of openness.
Shama?
And we have several such conferences earlier.
Sir, what was the need to revisit these fit and proper person criteria now, and how is SEBI planning to strike a balance between these integrity checks and ease of doing business?
See, the ease of doing, the point is we have to be clear that we are doing a proportionate regulations here. The capital market participants, they require also a predictability. We cannot have anything which is disproportionate in terms of when we want to curb. Secondly, we are, as you are aware, that every order in SEBI is appealable in SAT, and then it goes to Supreme Court also. So therefore, what is required is a lawful regulation, lawful use of powers, and we will not shy away from using the lawful use of powers. But we, in my opinion, we have plenty of powers, and what we require is possibly, more mobilization, more capacity building, and better thing, and, our quality of orders needs to constantly improve. And obviously, as media, you are also commenting on our orders when the orders are put out.
I think I just add, here, I think this is a very common, that question also came on fit and proper. It is not always that when you do steps for market development, it compromises investor education. It does not happen always. Sometimes it may happen, but it is not that they are mutually exclusive. For example, if there is an allegation against a market intermediaries, does investor protection means that you cancel the license of that market intermediaries? Probably not. The investor protection is that you investigate, and if you find conclusion is that yes, there is a violation, then you take action. That is actual investor protection, and that is how our constitution also demands. So I think we all are subservient to our constitution. Constitution doesn't say that just on allegation you remove somebody. So that also have to be kept in mind.
नमस्ते सर, अनुराग सर इस तरफ। सर, जैसा कि सेबी का और आपका भी हमेशा से ये फोकस रहा है कि जो छोटे भागीदार है, छोटे निवेशक है, उनके हितों की रक्षा की जाए, और कई सारे फैसले आपने लिए, कई सारे कदम हमने देखा है कि पिछले वक्त में आपके द्वारा लिए गए हैं। हमने देखा सर कि सरकार के द्वारा चिंता जाहिर की गई थी, वित्त मंत्री ने चिंता जताई थी बजट में, और अपनी एक इंटेंट शो किया था एफएनओ के नुकसान से जुड़ा हुआ। तो सर, जो सरकार का इंटेंट था उस पे क्या सेबी भी आगे बढ़ रहा है? सरकार की मंशा पर सेबी आगे बढ़ रहा है? अभी सेबी वेट एंड वॉच की मूड में है। और सर, दूसरा सवाल होगा, जिस तरह से अभी आपने कहा कि नोबडी इज एक्सपेक्टेड टू मेक इंसुएशन विदाउट एविडेंस एज इट डज हैव इम्पैक्ट। तो सर, इसके ऊपर एक्शन लेने के लिए सेबी के अभी नियम है या आप और सख्त नियम करेंगे इसमें?
एफएनओ पर तो मैंने पहले कहा है कि अभी जैसी स्थिति है वैसी ही है। तो हम इसको मार्च तक का डेटा जो आएगा उसको एनालाइज करके वी विल पुट इट आउट। जुलाई 25 में हमने पुट आउट किया था पिछले सालों का डेटा। उसके बाद अक्टूबर 24 में हमने कुछ मेजर्स लिए थे। जुलाई 25 में फिर हमने कुछ अनाउंसमेंट्स की थी। दिसंबर 6 तक उसका जो 6 स्टेप है, तो 6 मेजर्स हमने लिए थे। उन मेजर्स का इम्पैक्ट प्राइमा फेसी हमें दिखा है, लेकिन एग्जैक्टली हमको डेटा से उसको मतलब करना है, और डेटा को वी विल बी पुटिंग इट आउट in the public domain, and then decide how to do and what intervention we will require and in what manner. सो वेट एंड वॉच का मतलब ये होता है कि जब आप कुछ मेजर्स लेते हैं उसके इम्पैक्ट के लिए तो कुछ आप हम लोग वेट करेंगे कि धड़ाधड़ करते ही जाएंगे, बट पता नहीं क्या हो रहा है क्या नहीं हो रहा।
सर दूसरा सवाल सर,
the point on eligibility criteria, what would you say about it? Because I understand at some point SEBI was considering some kind of eligibility criteria, but nothing happened. And now when NSE Deputy CEO makes the same comment, how would you respond to that, sir?
You ask him.
सर माफी चाहूंगा सर, मेरा दूसरा सवाल रह गया सर। सर अभी आपने अपने संबोधन में कहा कि nobody is expected to make insinuation without evidence as it does have impact and independent director has to be responsible. नियम है वो अभी सख्त है या उसमें आपका विचार है कि उसको और सख्त किए जा सके जिससे जो छोटे निवेशक है, माइनॉरिटी शेयर होल्डर्स का नुकसान नहीं हो?
नियम तो ठीक है, नियम में क्या प्रॉब्लम है? यदि मतलब whether the action is consistent with the niyam.
Sir, here. Sir, so one, I have a two-part question, if you will. 1 and 2 NFOs have underperformed in the past 5 to 6 years, and AMCs have been mandated to do some investor education. So at volatile times like this, how will investors differentiate between a buy recommendation and a buy advertisement of AMCs? This is one. And SEBI has also been doing a lot of investor awareness. In the past year in your office, have you seen remarkable or significant changes in the way investors are investing? Has the awareness increased?
See, the investor awareness certainly is a very wide area, and I think if more we do, always we get a feeling that we are not doing enough. So therefore, this is one area where we need to actually further ramp up, and we have to do it together. When we are together is like passing rules and writing thing and making some press statements is not enough. There has to be a much activated role, and we have to really go deep down. So the first is that we came out with an investor survey. It gives us a lot of concrete ideas of what's going in the market, on the vis-a-vis, what's going with the people, what are their perception. The second, now we have worked out a project Jagruk. In the project Jagruk, we are combining the resources of all the SEBI and ecosystem and MP and market infrastructure institution together in order to do a massive campaign, which will also involve some of the issues that you have raised. Like some of the issues which you have rightly raised is what do you consider responsible investing? How do you say that we should allocate the portfolios and so on? Where does your, in the portfolios of your investment, where does bond come in? Today you are not even talking of bond, everybody is talking of equity. So all these issues that we are now bringing into the table of creating the whole lot of themes to do that. Besides, we will also be opening a WhatsApp channel, like RBI's WhatsApp channel, where we will go for, lot of interactive as well as other informational requirements from the regulator to people at large. So these are some of the things, and I'll request Sandeep to further throw light on these measures which we are planning.
Thank you, sir. So we are, we had a series of discussion with MIIs and MFI, and we have decided to, distribute the different 6 work areas amongst ourselves. And all of us have agreed that there is a necessity of having a unified campaign. At the same time, there will be one theme which can run over a period of, say, maybe 6 months or a year or so. But at the same time, some sub-theme will also continue to be part of the unified campaign. Apart from the unified campaign, each MIIs is also free to carry out their own investor awareness campaigns the way they are doing. The investor campaign is going to be two parts. One is digital and one is physical. So as you are aware, a lot of investor Nivesh Shivers and some programs go on at a different part of the country. Some of them are conducted by NSC, some of BSc, and MFI also conducts various programs. So we are also going to synergize and have a few programs, but which will have a more impact. One of the program will be, for which you already done a pilot, is with the Panchayati Raj. Through the Panchayati Raj department, we are reaching out to the states, as well as through states we are reaching out to the district administration and the local administration, and getting hold of the local administration people to educate them about the investor awareness, who in turn will spread the awareness amongst different people of the country.
Let's take just one or two last questions. Rajesh, you were saying something?
So,
सर दो सवाल थे. एक सवाल ये था डिस्क्लोजर को लेके हमने इतने रिफाइंड रेगुलेशंस हैं, बाकायदा मॉनेटरी थ्रेशोल्ड हैं और सब कुछ डिफाइंड है. उसके बाद भी हम देखते हैं कि कंपनियां अगर चाह लेती हैं कि उन्हें नहीं मानना है कि ये मटेरियल डिस्क्लोजर है तो वो नहीं मानती हैं. एक एयरलाइंस के ऑपरेशंस 10 दिन तक और उससे ज्यादा अफेक्टेड रहे, लेकिन शायद उन्होंने माना नहीं कि ये मटेरियल इशू था जिसको डिस्क्लोज करना चाहिए था. तो एक सवाल ये है, तो उस पर मार्केट ने पनिश किया उनके स्टॉक को, ठीक है वो सब, लेकिन एज ए एक्सचेंज या एज ए रेगुलेटर क्या इसमें और क्या किया जा सकता है या किस तरह से इसको देखा जा रहा है? एक सवाल. दूसरा ये था कि सर आपने कहा था कि सारे फाइनेंशियल इन्वेस्टमेंट का कंसोलिडेटेड स्टेटमेंट एक ऐसा हो इस पर, तो इस पर कोई अपडेट है आपके पास कि आपने कहीं किसी और रेगुलेटर से बात की या कुछ इस पर कोई फर्दर प्रोग्रेस?
देखिए, पहला जो आपका सवाल था तो उसके अंदर ये है कि रेगुलेशंस अपनी जगह पे सही हैं, और वैसे एलओडीआर रेगुलेशन के लिए जैसे आपको पहले भी बताया गया था, एक कमेटी बनी हुई है जो कि देख रही है कि इसमें क्या क्या बदलाव किए जा सकते हैं, कैसे नए रूप में इस रेगुलेशन को लाया जा सकता है. लेकिन जो पर्टिकुलर आपने बात कही किसी के बारे में, तो ऐसा नहीं है. जब भी मार्केट में कोई भी इस तरह की बातें आती हैं, कोई कंप्लेंट आती है या खुद हमारी निगरानी से कुछ मालूम पड़ता है, हम सबके डिस्क्लोजर देखते हैं कि सही है या नहीं है. अगर सही नहीं होते तो उनके ऊपर कार्रवाई की जाती है. कार्रवाई कई तरीके की हो सकती है कि अगर वो छोटे लेवल का वायलेशन है तो एडमिनिस्ट्रेटिव वार्निंग भी हो सकती है, थोड़ा बड़े लेवल का है तो पेनल्टी हो सकती है, कोई और बड़ा हो तो 11B के लिए रिकमेंडेशन हो सकती है, या इंटाइम ऑर्डर भी हो सकता है. तो वो सब एक अलग अलग लेवल के ऊपर वो सब है. लेकिन ऐसा नहीं है कि हम उसकी जांच पड़ताल नहीं करते हैं. जब भी जो भी मामला सामने आता है उसकी जांच पड़ताल होती है. और जो कैश की आपने बात कही, वो तो वो भी बात चल रही है सभी फाइनेंशियल रेगुलेटर का. आप देख रहे हैं, कौन देख रहे हैं? तो वो भी बात चल रही है, उसके ऊपर कार्यवाही चालू है कि किस तरह से, क्योंकि अकाउंट एग्रीगेटर है, अकाउंट एग्रीगेटर के पास में बैंकिंग डेटा है, तो उसको भी हम लेकर किस तरह से कैश में शामिल कर सकते हैं. क्योंकि ये बहुत अच्छा फीडबैक आया है कि कैश की वजह से लोगों को बहुत ही सुविधा होती है. क्यों? उसकी एक स्टेटमेंट में उसके सारे सिक्योरिटी मार्केट के एसेट मालूम पड़ जाते हैं. तो उन्हीं लोगों से ये होता है कि भैया अगर मेरे को सारे सिक्योरिटी मार्केट के एसेट एक जगह हैं, इसी में मेरे बैंक के भी आ जाएं. हम सब जानते हैं कि जब परिवार में किसी की मृत्यु हो जाती है तो उसके जो लीगल हेयर हैं उनको कितनी तकलीफ होती है. उनको पता ही नहीं होता कि कहाँ कहाँ उन्होंने अपने एसेट रखे हुए हैं. इस तरह के स्टेटमेंट हम अगर बना देंगे जिसके लिए पूरी हमारी कार्रवाई चल रही है, तो ये एक बहुत ही अच्छा सुविधाजनक प्रयास होगा.
So just to add, Prajesh, if you look at the LODR, जो कुछ parts है material definition के, there is no choice. There is a finite list. There is a finite list कि ये material है, you have no choice. Something has to be discretionary depending on the facts and circumstances. I thought I'll just highlight this also. It's not that we've left it completely open. नहीं specific में ना जाए, मतलब we don't discuss specific cases.
Sir, namaskar. Saurabh Pandey, INS Wire Service. Sir, with the new FPI net settlement framework, can we say that SEBI is trying to prioritize operational efficiency at the cost of expense of market stability when indices come under the process of rebalancing?
किसके expense किसका है?
जी sir.
At the expense of what?
Market expense, sir.
कैसे? Sorry.
My bad. नहीं कैसे? आप थोड़ा बताएंगे कैसे?
Sir, does the new FPI net settlement framework prioritize operational efficiency at the expense of market stability when indices undergo the process of rebalancing?
नहीं, मार्केट स्टेबिलिटी कैसे इम्पैक्ट होगी उसमें? हम ये तो बड़ी मतलब सीधी सी बात है कि आपने पैसा देना है और आपने कुछ पैसा लेना है, तो नेट के बेसिस पे आपको बोला जाए कि इतना पैसा दे दो. बहुत जगह तो नेटिंग होती है. इन द एफपीआई केस हमने बनाया हुआ था कि ग्रॉस बेसिस पे हो रहा है. अभी हम कह रहे हैं कि ग्रॉस बेसिस पे नहीं होगा, नेट बेसिस पे होगा. और नेट में भी तब विद राइडर है कि हम आउटराइट को ही करेंगे, नॉन आउटराइट को नहीं करेंगे. यानी कि ऐसा नहीं होगा कि आपने परचेज किया, सेल किया, परचेज किया, सेल किया, एक ही सेटलमेंट साइकिल में डे ट्रेडिंग कर दी और अब नेट कर रहे हैं. उसमें आप कह सकते हैं कि मार्केट में आप एक बड़े बड़े इंस्टीट्यूशन हैं, वो मार्केट को इम्पैक्ट कर सकते हैं. लेकिन ये तो हम अलाउ ही नहीं कर रहे हैं. हम तो ये कह रहे हैं कि उस साइकिल में यदि आप परचेज कर रहे हो ए स्क्रिप्ट और खरीद रहे हो बी स्क्रिप्ट, तो उनका जो आपस में वो है, तो उनकी जो फंडिंग रिक्वायरमेंट नेटिंग के बेसिस पे होगी. और ग्रॉस बेसिस में वैसे सेटलमेंट होगा सिक्योरिटीज का, क्योंकि उसके लिए हमें एसटीटी वगैरह तो ग्रॉस पे देना होगा, तो वो भी हमने लिखा हुआ है. तो आप यदि कंसल्टेशन पेपर ध्यान से पढ़ेंगे तो उसमें से आपको ये लग जाएगा कि इसमें कोई मार्केट स्टेबिलिटी का इशू नहीं है.
Sir, is this going to be done at the custodian level? This entire netting, because many of the FIs come through multiple brokers into the market.
तो वो आपको जो है आपके सर्कुलर में आ जाएगा. एक तरफ क्लियरिंग कॉर्पोरेशन है, एक तरफ कस्टोडियन है, एक तरफ एफपीआई है. एफपीआई के फंड हैं, कस्टोडियन के पास सिक्योरिटीज है, उसको ऑथराइज उसने किया हुआ है. क्लियरिंग कॉर्पोरेशन के सीसी के साथ वो है. सो इफ यू जस्ट सी, यू नो, even the consultation paper you see, there is a table which has been given, charts 1 2 3, vis-a-vis CC क्या होगा, vis-a-vis क्या होगा, और यदि outright क्या होगा, non outright क्या होगा.
So just
but
to
anyway
add,
you can also, if you want further understanding on that Aparna or Ruchi will be able to brief you.
So custodian का CCI के साथ already net basis पे होता है. So अभी FPI का जो gross basis पे हो रहा है custodian के साथ, वो net basis.
Good evening, sir. Charu Singh here from the Morning Context. I have a question on investor awareness. Sandeep sir said that you are working with other MIIs also to sort of divide the work and, you know, properly do it and reach the masses. But there's just one concern, as we know that the number of investment advisors is reducing, and if we work with the MIIs to go to the masses in the root level, is there any chance of having some sort of a biased advice given at a mass level due to an influx of sub-brokers or distributors from AMCs, something like that? I mean, is that not a possibility if we do it with AMCs and other intermediaries? This is just for my understanding.
Yeah, so, you know, when we have a unified campaign, we are going to also have a unified, you know, content also. So that we will take care. But apart from that, MFI or any other MIIs or any other institution is free to do their own, you know, campaign which suits their business or to increase the investment awareness.
So thank you very much. I think you will have a lot of queries. It's endless, and we already spent 1.5 hours. Thank you, sir. Thank you, sir.
Thank you.
If you please stop, there is one more announcement I have to make before you leave. So we want to see you on 25th as well. I'll give you the details of which, probably tomorrow I'll share the details of which, and we'll be seeing all of you on 25th as well.
25th off? 25th off?